A revocable trust is an entity or a contract for when you die that basically does the same thing as a will. Tells you who your beneficiaries are, who's going to be in charge of the estate. That would be the successor trustee. But the most important thing is a revocable trust avoids a probate proceeding. You are able to avoid the probate proceeding with a revocable trust, and no court supervision is going to be required. Now, that's not to say that you can't go to court in the future if somebody should do something wrong, the trustee stealing fees, anything of that nature, but you only go into court if there's a problem. Whereas if you have a will or no will, you go into the probate courts to begin with and have to deal with the time and expense that was mentioned before. So by far the best way to have your estate is to have a revocable trust. It's the most efficient and quickest way to get your assets distributed to your heirs. If there's no house that needs to be sold, then your estate, the trust estate, can usually be wound up within 4 or 5 months of the date of death. Whereas, like I said, a will or a null will going through the probates will be 12 to 16 months. A trust has to have 3 different parties. Has to have a trustor. Those are these individuals whose assets are placed into the trust estate. It has a trustee. That's the individual who's responsible for taking care of the trust estate. And there's also beneficiaries. These are the individuals who ultimately receive the assets. A trust has to have those 3 individuals or entities, otherwise the trust will fail because it's incomplete. A trust is also much more capable of putting strings on the money. For example, if you want your children to get a third at age 21, a third at age 25, and a third at age 30, a trust is able to do that. Say you want the trust to wait 5 years after you pass away before distributing assets. A trust can do that. So a trust is much more malleable with respect to different conditions and strings according to the beneficiaries. Now, an individual or a beneficiary may be on governmental assistance. There's a certain clause within the trust called a special needs trust that can allow a beneficiary to receive governmental benefits when an individual is to receive a distribution. It goes into a special type of trust, and essentially the government doesn't really count those assets as the individuals. I'm not going to get much more into special needs trusts, but if you'd like, you can give us a call and we'd be happy to give any sort of information with the trust to you. If an individual is on Medi-Cal, not Medicare, but Medi-Cal, and they have a trust, as the law currently stands today, Medi-Cal or the state of California is not able to recover against assets that are titled in the name of a trust. As long as the asset's titled in the name of the trust, it is not subject to recovery from the state, which is a good thing, because any assets that are not in a trust or do not have a beneficiary are subject to recovery by the state of California if the deceased individual or their spouse received any sort of Medi-Cal benefits during their lifetime.